Please rise. Justices of the Appellate Division, Supreme Court, First Department. Hear ye, hear ye, all persons having business with the Appellate Division. Draw near, give your attendance, and you shall be heard. Please be seated.
Good afternoon and welcome to the Appellate Division. Before we call the calendar, I'm going to turn the proceedings over to my colleague, Justice Kapnick.
Well, thank you very much, Justice Gish. It has always been the tradition of this court, when one of our colleagues sits on the bench for the last time, to have the JP, the Justice in the center presiding over the panel, make a few remarks on behalf of the court. Today, since it is actually our JP who is sitting on the bench for the last time, I, as the next most senior judge, have the very bittersweet honor and privilege of making those remarks for our colleague and friend. I'm sure Justice Gish would be the first person to tell you that she cannot figure out where the last 10 years have gone since she was appointed to the Appellate Division in October 2012, exactly 10 years ago, or in fact, where the past 32 years have gone since she began her judicial career when she was first appointed as a housing court judge in May of 1990. The timing of our two judicial careers has been very similar. We have moved up the ranks, so to speak, in the court system pretty simultaneously. So I can only begin to imagine all the mixed emotions Justice Gish must be feeling today. Being a member of the excellent judiciary in this great state of New York is a dream come true for every one of us, and also an enormous responsibility which we all take extremely seriously. And sitting as a justice in this landmarked, gorgeous Appellate Division First Department, where everyone works together so collegially, is certainly the highlight of any New York State judge's judicial career. Justice Gish is so smart, always asking thoughtful, probing, and insightful questions to the lawyers so we can get to the heart of the legal issues raised and understand your arguments to the fullest and ultimately reach the right result. And this is true not only as to Justice Gish's 10 years here in the Appellate Division, but this is also how she approached her cases in the housing and civil and Supreme Courts, where she developed her reputation as an outstanding judge in many areas of the law, spending many years working in the matrimonial part, most recently before coming to the Appellate Division. She is also a beautiful and articulate speaker and writer, and leaves our court and the jurisprudence of this state with many brilliant and thoughtful decisions, many of which I have had the honor of joining in on. Justice Gish did not have to retire this year because of age or any other reason, but she made the choice to leave this year on her own terms. Maybe to spend more time with her husband of many years, Steve Shirkman, who is here in the courtroom today, himself a very respected trust and estates attorney. Or maybe to spend more time with her almost 3-year-old grandson, Henry, who now lives upstate and who Justice Gish always describes as delicious. Or maybe to spend more time with her sons, Ethan and Zachary, who I hope are watching on the YouTube right now, or her daughter-in-law. Or maybe to have the freedom to embark on new adventures, or most likely all of the above. But we will definitely miss you here in this court, Judy, working with us on a day-to-day basis, and we're glad to know that at least you are going to continue to serve on the PJI committee and the Chief Judge's Advisory Committee on Evidence, so you can continue to contribute to the development of the substantive and evidentiary law of our courts. And I would be remiss if I did not mention that we are not only losing Justice Gish at the end of this year, but also her principal court attorney, Eileen Casper, who has been working with Justice Gish for approximately 25 years. Every judge here will acknowledge how important our court attorneys are in every aspect of our daily work. We could not do what we do without them. And many of us, including Justice Gish and myself, worked early in our careers as court attorneys and judicial clerks. It has been a pleasure working with you, Eileen, as well, and we wish you a wonderful retirement also. We will miss your guidance and upbeat disposition around here as well. So, Judy, I know you will be here with us at the court till the end of the year, and we will have other celebrations. But today is certainly a milestone to remember and cherish. I'm sure it feels like just yesterday when you were up here sitting for your very first time on the bench, and the JP of that bench spoke about you, another of our court traditions, on the occasion of your first sitting. Time certainly flies, and we just have to try and enjoy every minute to the best of our abilities. We know you will be terrific and successful at whatever you choose to do going forward, and we will, of course, all stay friends. But here at the Appellate Division, we will miss seeing you every day, and we will miss your very important contributions to our work. So I just want to wish you, and all of us want to wish you, best wishes, good luck, and Godspeed in everything you set out to do.
You know this is overwhelming. It's overwhelming. But let me start out. Justice Kapnick, let me thank you for your kind words. You are a generous colleague and a good friend, and it's really an honor to have you speak about me here today. And you hit it right on the head. Today is bittersweet. I don't know how else to explain the range of emotions that I feel about this being the last time that I will be wearing black robes and sitting on a bench, at least in an official capacity, and at least sitting on a judicial bench. Maybe I'll be on a bench near a beach after this. But time will tell. Time will tell. Overwhelmingly, though, this afternoon, I am filled with tremendous gratitude for the privilege of serving the public these many years. 32 years, 10 of which were at this august court. So for all of you gathered here today, both in person and virtually, to all the attorneys who have appeared before me in the courthouses of this state, to all the clerks, the court personnel, the court officers that have served and protected me over these years, to all the staff attorneys who have used their considered and collective legal acumen to help me toward the delivery of justice. To all my colleagues all over the state who have served as judges on the trial and appellate courts, and especially to my colleagues here at the Appellate Division. To my Chief Judge, Rolando Acosta, for your guidance and support these years. And yes, to Eileen Casper, my principal court attorney for over 25 years. Well, you've all heard that my husband of 40 years is here today. Eileen is my work spouse. I see her maybe sometimes more than I see Stephen, and I will certainly miss your guidance over the years. And to all of you, all of those who I have mentioned, I say thank you. We have all agreed on some things, and God knows we have certainly disagreed on many things. We have considered the arguments top to bottom, both together, and then reconsidered them all over again. We have done our best to solve problems of those who come before us, to serve the public, and to follow the rule of law. Yes, there's been a lot of talk about the rule of law in these past years, but we live it. We live it every single day. I have learned so much from all of you, and because of all of you, I leave the bench a better judge, a better person than when I began this journey. I leave with confidence that in the future, in our vibrant, thriving system of justice here in the state of New York. So to conclude, the only thing I can say is, let's call today's calendar. So here's a popular thing that you've heard me say. We have more time requested for oral argument than we have hours in the afternoon. So when I call your case, please only ask for the time that you reasonably need. The first case, People versus Franceschini. Submit. Williams versus the City of New York. Do we have questions, colleagues? Okay, thank you. We'll mark it submit. Ramos versus O'Neill. Submit. Rivera versus City of New York. What time do you want? All right, 5 and 2 for rebuttal for the appellant, 5 for the respondent. Godbain versus 111 John Realty. All right, I'm going to give Gem Star, I'll give you 5 and 1. Plaintiff, I'm going to give you 4 and 1 for rebuttal, and 111 respondent, I'll give you 5. Bank of New York versus Nunez. No respondent. Do you still wish to argue? Colleagues? We'll mark it submitted. Thank you. People versus Fonseca.
Respondent requests 5 minutes, Your Honor.
7, 2, and 5. Thank you. Curry versus Martin.
Appellate requests 4 and 2, Your Honor.
4, 2, and 3. Thank you. Jackson versus Main Street American.
8 and 2.
5, 2, and 5. Thank you. Kamara versus 323 PAS owner. 5, 2, and 5. Thank you. Stiegelman versus Transservice lease.
Bless you.
Thank you. Bless you. Which respondent are you? Oh, you represent both respondents, and what are you asking for? 5, 2, and 5. Thank you. Asagian versus Asagian, and I'm sorry if I mispronounced that. But apparently nobody's here to correct me, so submitted. Ahmed versus 2 West 46th Street. 5, 2, and 5. Thank you, counselors. Lee versus Lancaster, submitted. Mejia versus De La Rosa, submitted. Okay, first case on the calendar is Rivera versus the City of New York, and Justice Gesmer is recused on that case. Okay, Counselor, you can proceed.
Good afternoon. May it please the court, Josh Olmsted for the plaintiff appellant. Your Honors, the decision from the Supreme Court should be reversed for two reasons. One, they failed to meet their prima facie burden as a question of fact exists as to whether they have prior written notice. In their motion, the city produced a Big Apple map. That Big Apple map is document 575 of the record. In that Big Apple map, you have the correct location of where the incident occurred, which is 171 East 115th Street between Lexington and 3rd Avenue. On that Big Apple map, it shows an X. The X is located off the T. So on the map, it has East 115. If you look at the word East and off the T, you will see an X. That X is in the vicinity of 171 East 115th Street. You can also look on the
And I'm
map.
going to ask, because I looked at the map, and the one in the record was in fact quite grainy, but as I read the map, and you can correct me if I'm wrong, the X, which would denote that there was a problem on the curb, was for 177.
It's our position that that is in the vicinity, which is right next to 171, right across from the school. And according to the case law in this department, the precise location of the defect and whether the defect is on the map is a question for the jury to decide. So it is our position that the Supreme Court should have seen the X, should have realized the X was in the vicinity of where the plaintiff testified, and denied the city's motion as a question of fact. So in other words, we have the map, we have the right location. Importantly, we have the right defect symbol, which is a broken curb, all within the vicinity where...
Does it matter here that no claim is I'll take it back.
No problem. Second, I'll be brief. The second reason the Supreme Court decision should be reversed is that it is premature. Again, this is something that you can look to the record. If you look at documents 587 to 592, you will see photographs of the defect. In those photographs, you will see what appears to be patching, as if someone tried to patch that hole. Either the co-defendants did it or the city did it. We don't know if the city did it because the city moved before we could depose anyone from the city. The city admits they produced voluminous records in response to our demands. The Supreme Court acknowledges that voluminous records were produced. It's our position that we need to get a deposition of the city and that it's not a speculative request. It's evidence they have in their control, and it's not speculative because we have a picture with patching in it. This department has held pictures with patches typically are a question of fact and typically are not speculative. Thank you.
Thank you.
Good afternoon, Your Honors. Julie Steiner for the respondent, City of New York. The Supreme Court correctly granted summary judgment because no matter where the accident occurred, whether on the curb or on the sidewalk, either the city was not responsible for it under 7210 of the Administrative Code, or it did not have prior written notice. If on the sidewalk, it is clear that under 7210, liability shifts to the abutting property owner, and here it is undisputed that this property was neither a 1, 2, or 3 bedroom, a 3-family residential building, and the voluminous documents of the Department of Transportation indicates that the city performed no work. So none of the exceptions apply, and plaintiff has not shown otherwise. If it occurred on the curb, there is no prior written notice. The voluminous records from the Department of Transportation either pertain to an accident location, a location that was not the accident, and any record relating to a sidewalk, of course, again, under 7210, does not render the city liable. And the Big Apple map to which the plaintiff refers only shows a localized defect, an X, a single X, in front of 177 East 151st Street.
What about counsel's position that the law in this state allows it to be in the vicinity, so it could have been premature not to have made this determination before the city was deposed.
So the vicinity or the somewhere nearby language that the plaintiff is fostering is incorrect. That is not the law of the state. In fact, both this court and the Court of Appeals, particularly in Roldan versus the city in 2007, and then the Court of Appeals in Leary versus Rochester, clearly and explicitly rejected the somewhere nearby. The city needs to have prior written notice of the specific defect and the specific location. So the fact that, and this court can take judicial notice of it, the more clearer version of this map that was put in the city's motion for, plaintiff's motion for re-argument, you will see that it shows the X, a single X, which means a single curb defect, not an extended curb defect, in front of 177, nowhere near in front of 177, regardless that the two addresses are neighboring or right next door to one another. So in that sense, that does not provide prior written notice. And finally, as to his premature argument, all the two affidavits from Mr. Attic from the Department of Finance goes to ownership. There's nothing more that he would testify to indicate that the city did or did not own. Clearly, the city did not. And as for Mr. Bakshis from the Department of Transportation, he indicated in his affidavit what the search that he conducted and the result of that search. And all of those documents show that the city did not do any work in the area in the 2 years preceding to the accident. There's nothing more for either of these witnesses to testify to, so the city's motion was not premature. And for that reason, the Supreme Court's order was correct, and this court should affirm. And, Your Honor, it has been a pleasure for the last 10 years to appear before you. Good luck. Thank you.
Thank you. That won't affect the decision.
In response, I would just add that the affidavits that were provided by the city, they don't discuss anything about cause and create. They just basically say, we don't own the property, and we did a search, and here's what we found. So we were unable to...
But if they say that they did a search and there had been no work done by the city in the past 2 years, so how could they have caused the alleged defect?
Well, that would be why we would need to depose them. The fact is, there's a patch. So they can say they didn't do it, but we have evidence that someone did it, and we would have to depose them whether they did it or not.
Well, if they say they didn't do it...
Well, they don't say they didn't do it. They don't talk about whether they did it or not. All they say is they did a search, and here's some inspections. But they don't go into whether they created it or patched it or did anything.
Well,
because the motion is premature, that's why.
I mean, the search indicates that they have no record that they did any work in the area.
The search only indicates that they had multiple permits, multiple street opening permits. They had other inspections that were done. The records were voluminous. Respondent says they were voluminous. The court says it's voluminous. We have a picture of a patch. That's why we needed to depose the city to figure out
But
what they did or what
wouldn't
they
the
didn't
city
do.
have to have records if they did work there?
That's what I would like to know. That's why I would like
But
to
they
depose the
produce
city.
the records, though.
I
So
don't-
so wouldn't, in other words, you know, when you're saying it's premature because you need discovery, you have to show that there's a basis for obtaining discovery, and you're saying that the patch itself is enough?
I'm saying that patch itself is enough. It's a question of fact, and in this department, they have held that where there's photos of patches, that is a question of fact, and that's enough. Additionally, regarding cause and create, I would just like to add that we allege that in the notice of claim that is in the bill of particulars. Also, there's recent cases that this court has held that the precise location of the defect and whether the defect is a designation on the map should be resolved by the jury. Multiple cases. This one is Sanchez v. City of New York. That's 176 83rd 480. Most recently, you decided a case, Bagley versus 122 East 180th Street, 203.
Well, if the sites are in your
83rd,
briefs,
sorry.
you don't have to.
Yeah, 203 83rd 3302. Thank you.
Thank you, thank you, thank you both. The next case is Godbane versus 111 John Realty. I see is there discussion about which appellant should go first?
Yes, he was raising that issue with me.
And you represent the plaintiff. All right, in the absence of an agreement for the or the additional appellant, we're going to let you go first. We're going to let the plaintiff be heard first.
Thank you, Your Honors. May it please the court, Eileen Kaplan, Alephtorakis, and Panic for the plaintiff appellant. It's respectfully submitted that the Supreme Court erred in dismissing the plaintiff's complaint based on the reasoning that defendants, the John Realty defendants, owed no duty of care to the plaintiff as a matter of law. As Your Honors know, from the record, there was robust testimony from Mark Riffkogel that the defendants traversed the staircase in question regularly, frequently. They didn't have to ask for permission, and they needed to do so to operate the building. There was robust and detailed testimony on this point.
Well, didn't 111 John Realty, who owned the building, lease the premises to 7-Eleven, and weren't they responsible for taking care of the stairs? And because 111 John Realty in this case was an out-of-possession landlord?
Your Honor, it's respectfully submitted that there was a lease, but that nonetheless there's a question of fact as to whether their duty of care has been relinquished. They reserved a portion, they expressly in the lease at 1064 or 5.
They had like some pipes and things and meters downstairs in the basement. They retained possession of that space.
They reserved, and they expressly in the lease, they reserved, and this was a point which was not brought out in the Mallet case, they reserved an actual room in the cellar for their own use.
Isn't it clear that under the terms of the lease itself, they were not responsible for the repair of the stairs, that was expressly part of the duty of the tenant, 7-Eleven, to repair and maintain the steps?
Thank you for the question, Your Honor. Number one, I don't think it's clear from the lease itself. They've highlighted the portion which I think they would term mere right of reentry. But there's another clause of the lease which says that they can go down there to perform their obligations. Moreover, there is this diagram where they've expressly reserved this room to get back to the question, to come full circle, I think there's a question on the lease, and the lease alone is not enough. I spoke about the Gronsky case in my brief. It's conceded that the Gronsky case from the Court of Appeals had to do with a license and not a lease. But in appellate division cases, that same analysis, at bottom, use, control, possession, when there is a course of conduct which shows that, and here we have a confluence of factors.
Weren't the steps primarily used by the tenant to bring stuff up and down? I know there's some evidence that the landlord did use the steps occasionally to go down, but weren't they primarily used by the tenant to access the space in the basement?
I don't know if I would use the word primarily, and even if it was primarily, there was robust testimony from Mr. Riffkogel. We did not have that in the Mallet decision, in the Mallet litigation, whereby we have the defendants over the course of approximately 18 months from after Superstorm Sandy going down there to service not only the 7-Eleven, the pumps, the pipes, the fire department's regulations, they were required to go down there, and that was their sole means of access.
Even if that is true,
Yes.
and it seems that there was testimony that they did have to use those stairs to go down to check the water meter, the pipes, other things, didn't the lease make it clear that the responsibility to take care of those steps was belonged to the tenant and not to them, even though they were using those steps?
I think that when we speak about out of possession, it's not, we look at the lease, but we also look at conduct. We also look at conduct. I mean, that's clear from Rideau versus Goldberg, which was cited by the grant. We also look at conduct. And a lease, as the panel...
So your answer to my colleague's question is maybe the lease did, in fact, provide only for limited access, but you're relying on conduct?
I would say that I would disagree with the characterization of the lower court
Of
limited
the lease.
access.
I just want to know. I just want to know what
Yeah.
your answer is. I know the light's off, but I have another question for you. You sued both the managing agent and the owner. Is there a different theory of liability that you have against the managing agent in this case, such that dismissal against the managing agent was for any other reason inappropriate?
It's my understanding from the record that they're sort of one and the same, so to speak. The employees, Mr. Rifkogel, Mr. Tesser, get a paycheck from one, they talk to the other one, so I don't see any...
So it's the same theory of liability?
I would say so, Your Honor, yes.
Okay.
So when you say they're one and the same, you're not saying that they're the same entity, but that the same theory applies to them both? Which is it?
I think it's both, that they're one, I mean, I don't see, there's been no one, to my knowledge, has argued that, I don't think that the defendants argued that Braun should not be on the hook. I don't think that's one of their arguments, with John.
Okay, thank you.
Okay.
All right, let's hear from Appellant Gemstar.
Good morning, Your Honor, or sorry, good afternoon, Your Honors. May it please the court. Michael Martens for Appellant Respondent Gemstar. Gemstar is entitled to reversal of the lower court order which denied its motion for summary judgment. There is absolutely no evidence on the record, not based upon speculation, that Gemstar created the alleged condition or launched an instrument or force of harm so as to trigger one of the Espinal exceptions. Respondents do not contest or argue that the other two exceptions to Espinal apply, so I'll only focus on the launching of an instrument or force of harm exception. Gemstar didn't perform. Sorry?
If part of the responsibility of Gemstar was to correct any conditions in the lease premises, and there was testimony from a Gemstar representative that part of their work was to look at the stairs and see what the issues were. If they failed to do so, they did so in an inadequate way, wouldn't that raise an issue of fact as to whether they launched an instrument of harm based on the way they conducted their work on the renovation of the premises?
Well, when you look to the project bid form, the plan, the specifications, there's absolutely nothing in there that contains any work to the subject staircase. Moreover, it's my understanding that...
Didn't the construction manager specifically testify, though, that his work did include a review of the stairs? Any issues with the stairs?
So there was some minor work done to the stairs, particularly at the bottom of the staircase. It involved painting and some work on the railing, but the issue here is that the plaintiff slipped and fell on the top portion of the staircase.
Right, but there was
specifically
testimony that
top
the
step.
stairs were crumbling, that they were in pretty not good condition. If part of the job of Gemstar was to repair the premises, including the stairs generally, which is what the construction manager testified, if they left it in such a way that the stairs were crumbling and not repaired, wouldn't that raise an issue of fact
I mean,
as to whether they launched an instrument of harm in the way they performed their work.
it's our position that Gemstar had absolutely no obligation to repair the structural soundness of the staircase. There were some punch list items such as painting the bottom of the staircase, but nothing involved the top step in any of the work that they did, and they testified to that, and nothing concerned placing a metal covering over the staircase, which is ultimately what the plaintiff fell on.
Did anyone else in the project, any subcontractors or the like, perform work on the steps?
No, there's Gemstar, their testimony and the evidence is consistent that Gemstar didn't perform work on the stairs outside of these few punch list items that had no relevancy to the top of the staircase or a metal covering where the plaintiff allegedly fell.
Okay, but did anyone else, because Gemstar was the construction manager, were there any other contractors, subcontractors, et cetera, on the project at that time who performed work on the steps?
I believe if you look to the affidavit of the Gemstar project manager, Mr. Bruck, he testified to the fact that there was no subcontractors that worked on the top of the staircase or placed a metal covering on the staircase. And the respondents primarily rely on the testimony of Ms. Pinteris, who, you know, outside of the fact she was romantically involved with the plaintiff, she testified that there was she believes there was a metal covering installed, but she can't speak to who installed it or which entity installed it. And further, she didn't observe such installation. So her testimony is just based on pure speculation, and she will never be able to get to the root of this metal covering and who potentially installed it. We don't know the answer to that, and the jury...
Wouldn't that be the plaintiff's problem at trial? And
I think
summary
that,
judgment with your burden to affirmatively establish as a matter of law that you are not liable?
well, I think that at trial, the plaintiff would be relying on pure speculation to determine the cause of the accident and who installed it. The fact is that we don't know who installed it, and we affirmatively produced evidence to demonstrate that we didn't install a metal covering. The evidence on the record is consistent as to that. If you look at the blueprints, the plans, the specifications, punch list items, project grid form, our affidavit, our testimony, we didn't install a metal covering, we didn't work on the top of the staircase. John, the chief engineer of John Realty, testified that the staircase had been at the premises for 35 years, and during that entire duration, it had never changed. The staircase had never changed. There's also evidence on the record that demonstrates that we can't know if the defective condition existed at any time prior to the subject accident. The plaintiff testified that he walked up and down that staircase many times in the year after Gemstar completed its work, which was signed off on by 7-Eleven. So,
Well, weren't there other people who had personal knowledge of the staircase who said that after the work was done, the stairs were never quite right?
well,
There were lots of complaints about the stairs being wobbly before the accident.
Well, I reviewed the record briefly before here, and we have in our brief that there was no complaint received by 7-Eleven or John Realty as to the subject staircase. And 7-Eleven signed off on the work a year prior to the accident. So we cannot know if the defective condition even existed up until the date of the accident, because the plaintiff himself testified that he walked up and down that staircase many times without seeing an issue, and there were no complaints received by John Realty or 7-Eleven. If there's no questions.
No, I think we'll hear from you on rebuttal.
Okay.
Let's hear from the respondent.
Good afternoon. Kathleen Foley for John Realty and Braun. And I think in answer to one of the earlier questions is, legally, they're one and the same. The issues against...
Why are they one and the same? I mean, one's just, I know that's the way everybody's treated them in all the papers, but one is a manager and one's an owner, and legally there's different different standards of liability, so why are they being treated as one and
Right,
the
but
same,
they,
just on a
but
legal
the
basis?
lease agreement, the way it reads, all of the repair responsibility went to 7-Eleven nonetheless. Now, I don't actually know the history of their relationship. Perhaps there were other properties that were owned by Braun that were owned by John Realty that Braun had more involvement in, but that's not the case
So
here.
it's your position that if the owner is out, then the managing agent is likewise out of this case, correct?
I'm not saying always, I'm saying here.
Here.
Yeah.
And vice versa. If for some reason we reverse and bring John Realty back in, then we'd have to bring the managing agent back in as well.
I would think so. Plaintiff hasn't separated any claims against them. Everything is identical, so I believe they would rise and fall together.
What about the argument by plaintiff that the landlord in this case used the stairs on a very regular basis and was always going up and down the stairs?
Okay.
And therefore has some responsibility?
Right, but a course of conduct of using the stairs is not a course of conduct of maintaining or repairing the stairs, which is clearly in contravention to the written words of the contract. On page 1027 to 78, oh no, 1027, sorry. John Realty is supposed to maintain the foundation slab and structural soundness, keep in good repair any plumbing and electrical wiring, servicing to keep the roof and the exterior of the building. That's it. So the course of conduct is irrelevant. And obviously, since this was the only access to the water main, they had to use it. I mean, according to plaintiff's argument, if there was something wrong with the front door, that could also be put on John Realty because they had to use the door to access the stairs to access the basement. And that would make no sense. The same with the flooring. 7-Eleven is responsible for the flooring. If something happened that wasn't necessarily a transient condition, that wasn't created by John Realty themselves, then that would still go to 7-Eleven. And I think plaintiff did themselves a disservice by relying on the Mollett case, because in the Mollett case, it was a transitory wet condition that was allegedly created.
That was the issue of fact that they got held in
Correct.
on that case.
Correct.
Yes.
It's totally irrelevant as to this. This is just a typical out-of-premises landowner case who demises all use, control, and maintenance to make repairs to the owner, which is 7-Eleven, which obviously is a large corporation that wasn't bamboozled in any manner.
Now, your client had nothing to do with hiring Gemstar, did they? Was that all 7-Eleven, or was that your client?
That was 7-Eleven. I have no say as to Gemstar. But I do know that the 7-Eleven manager thought the stairs were still shaky because the metal covering did not fit properly. Now, somewhere plaintiff said they were crumbly. That doesn't make sense if there's a metal topping on it. I've never seen metal crumble under ordinary use. But if there was this metal covering, that again, whether Gemstar did it, maybe 7-Eleven did it themselves, I don't know.
And were there cross-claims between your clients and Gemstar?
I do not believe so. I'm sorry, I don't know that offhand, and since the record was about 400 pounds, I declined to bring it.
Okay.
Any other questions?
Thank you.
Thank you, Your Honors.
Let's hear rebuttal.
Your Honor, who do I respond to first now, or it doesn't matter?
You have your rebuttal. You're only getting one opportunity at rebuttal, so
Okay,
we can follow along whichever way you do it.
okay. I'll respond to the John Realty defendants first. You know, as I wrote in my brief, just because a lease is given, that doesn't cloak the owner in a suit of armor. It's just a presumptive transfer of control. And the court always looks to course of conduct, always. And just to get back to the lease.
But the course of conduct here didn't include them making any repairs to the stairs. They just used them to get to the mechanical room in the basement. Is that enough?
I think under these circumstances, it is, Your Honor, and thank you for raising that point, because I cogitated on that. Well, do we have to show that they undertook that? And I don't think we do. And that's because at bottom, use control is the question. And that's Court of Appeals law, again, from Rideau versus Goldberg. I don't have to show a specific undertaking of repair. If they're using the stairs to get to their reserved basement on a regular basis to fulfill their lease and legal requirements, then I think, I'm not looking to win the case on summary judgment. I'm just looking not to lose. The record has to...
We understand that.
Yeah.
You have a question?
So is it your position that an out-of-possession landlord that is not required by, who is relieved of responsibility to do repairs by the lease, if they walk through this space or use any part of the space that's demised, that they then have a responsibility to repair it? Is there any case law that supports that theory?
If I may respond to Your Honor, first, I don't feel that I handled the question on the first go-around about the lease as well as I should have. I don't agree with the characterization that this is a mere right to re-entry and it's completely unambiguous that they have no responsibility. There's clause 8A, which says structural soundness. In Gill versus Sofer, this court held stability of a staircase, or there was a question of fact as to whether that was structural. So I don't believe that they're completely off the hook. I think the lease is ambiguous. I think the lease is ambiguous on that point. That's pursuant to 8A. Structural soundness is on them. In Gill versus Sofer, the court said...
I'm gonna ask you to be a little bit more directed in your answer to my colleague's question.
Yes.
Because I was gonna give you just a bit more time. You're way over time.
Yes.
But I was gonna give you a bit more time to respond to Gemstar, and I don't want that argument to be lost in the sauce.
Thank you very much.
So just answer Judge Gesmer's question, and then let's move on to Gemstar.
I don't think it was a mere walkthrough. I don't think it was a mere walkthrough. Mr. Rifkogel testified sometimes when there was flooding in the basement 10 times a day. They went down there. The pumps, their equipment was down there. This wasn't like, oh, I'm in the mood, let's check out the premises.
Okay, now on Gemstar, right?
Okay.
Okay.
Yeah.
All right, I'm going to give you an extra minute, which is a lot of time.
I'll be quick.
So go ahead.
Thank you.
Please.
So with due respect to opposing counsel, when I hear him speaking about the record, I feel like he's reading a different record than I am. There were complaints about the stairs left and right, not just from the plaintiff, from Ms. Pinteris. I hear speculative. I have no idea why her testimony is speculative. She was there. She's a person with firsthand knowledge of what was going on. Moreover, as I think was set forth in the briefs, their obligations, Gemstar, they worked with 7-Eleven all the time. Mr. Bruck, Mr. Raphael, no one really had a clear idea of what the requirements were. It was sort of do what needs to be done to get it outfitted for the 7-Eleven. There was a 1-year warranty, there were punch lists, and so forth. So I feel like we're reading a different record.
Okay, thank you. All right.
Thank you.
We have Gemstar, you have rebuttal?
Thank you. Just briefly, Gemstar did assert cross claims against John Realty, and we also appealed to that portion of the order which denied our motion for summary judgment as to those cross-claims, and I believe they went unopposed on appeal.
Did they cross-claim against you as well? I'm not sure. Okay.
I believe so. I believe so, but I'm not positive. So 7-Eleven had a company, Vixo Corporation, which maintained all their complaints. There were no complaints reported to Vixo Corporation with respect to the staircase. There were some generalized complaints apparently floating around, but as far as formal complaints, none were received. Plaintiff states that, we're reading a different record, but at the end of the day, plaintiff can't point to anything which would demonstrate that Gemstar installed a metal covering on the staircase or that Gemstar worked on the top of the staircase, which is where the plaintiff fell. They can't point to a single thing outside of Ms. Pinteris' testimony, where she generally said, I believe a metal covering was installed. She cannot point to who installed it, which entity installed it. She didn't observe it being installed. So for those reasons, I believe the plaintiff's, allegations as to Gemstar installing the metal covering or work on the top step are speculative and do not warrant a jury trial as to Gemstar.
Thank you.
Thank you.
Thank you all. The next case for oral argument is People versus Fonseca. You may
Sean Nuttall.
proceed.
Thank you. Sean Nuttall for Appellant. Your Honors, when I'm done here today, I'm going to walk out that door, and I'm going to ask the panel to come with me. I'm not going to tell you where we're going, but I want you to promise me that wherever I lead, you will follow. That was basically the court's approach to voir dire in this case, and it's wrong. This court and the Court of Appeals have held that to have a fair opportunity to explore relevant legal issues with the juror, it is essential that the defendant be allowed to explore not just basic legal principles like the burden of proof, but also relevant legal issues to the case, like here, acting in concert or justification. For this inquiry to be meaningful, the jurors must receive some instruction on what these principles are. But here, the court refused to give that instruction, even when the jurors expressed clear confusion about the law. And while the people claim that only specific lines of inquiry were blocked, the record is very clear that, in fact, the court blockaded counsel from any attempt to discuss these relevant legal issues. In fact, counsel wasn't even allowed to say the words justification, self-defense, or acting in concert. Just like in Miller, where the Court of Appeals found that the defendant was impermissibly barred from inquiring into issues that went to the heart of the defense, Mr. Fonseca's rights were violated here. Sometimes the court's rulings approached a judicial game of whack-a-mole. The counsels were not allowed to use hypotheticals, but they also weren't allowed to approach the relevant issues in the case. They weren't allowed to ask about the law, but they also weren't allowed to go into the facts. The only thing the court insisted that was relevant was the jurors' blind assurance that they could follow the law no matter what the court's instructions were. That's just wrong. Porter, this court's case in Porter, expressly holds that this type of general assurance is not enough. As co-counsel here put it, after the court refused to help a confused juror, how could they possibly ascertain whether the jurors could fairly and impartially apply the law when the jurors didn't even know what the law was?
Let me ask you something. Let's assume for purposes of my question that some errors might have been made in terms of the questioning of the jurors. You also have to show prejudice, and this is a case where the defendant was actually not found guilty of some of the charges and only found guilty of some of the charges. So what evidence is there that the jurors who actually seated were not fairly listening to the evidence in this case and hearing the evidence in this case and applying the law, because all of your objections have to do with prospective questioning of jurors, but not with the way the trial itself was conducted or the way the jury charges were given at the end of the trial.
And I think that's absolutely appropriate, Your Honor. If you look at Porter or Miller or Stewart, there's absolutely no inquiry as to how the trial goes or what the verdict is.
Isn't prejudice one of the requirements you have to show?
Absolutely, but the prejudice exists during voir dire. The issue is how voir dire was
You're saying that even
conducted.
if it had no ultimate effect on the trial or how the jury decided this case, it's still reversible error?
Well, we think it absolutely had an effect on the case, but the issue is at voir dire.
What effect do you think it had on the case?
Let me go with you,
In light
Your
of the
Honor.
fact that he was acquitted of some of the charges.
Well, I think that points very much the other way, Your Honor. When you have an acquittal on 6 counts and a conviction on only 2, that points to a very close case. If the jury was really buying the justification defense, it would have applied to everything. And yet we don't know, because of the court's limitations on voir dire, whether the seated jurors were able to fairly and impartially apply that legal principle. We have no information. And in fact, just like in Stewart, where there is an extensive inquiry into prejudice, you have jurors here who were sat after making troublesome comments about the law. And counsel here said, look, Your Honor, we need more time.
Let me go back 1 second, because you focus on justification.
Yes.
Let me rephrase it. Let's say the court didn't err in justification, only erred in terms of the accomplice liability questioning. What then?
Same result, Your Honor.
What's the prejudice then in terms of how the verdict came out?
Same result. This is an issue that went to the heart of the defense. If the jury found that Mr. Fonseca was not acting in concert, the attempted gang assault conviction would fall. Counsel had to be allowed to go into those key legal issues. I think Porter, Miller, and Stewart all require reversal here. Again, it's our position that the court needs to look for prejudice at what happened in voir dire. In none of those cases do you look at the end result. But even so, I think looking at the end result, there's clearly prejudice here. When it came to exercising challenges, counsel was left shooting in the dark as to whether the jurors here could fairly and impartially apply those legal principles. And that's not fair. That fundamentally compromises Mr. Fonseca's right to a fair and impartial jury. I believe this, people point to preservation as being an issue. I couldn't disagree more. These arguments are amply preserved. I count almost 20 instances where counsel or co-counsel, both Mr. Fonseca's defense lawyer and the other lawyers, attempted to get into these principles, and the court shut them down repeatedly, explicitly, did not even let them use the words self-defense, justification, acting in concert.
Sir, could you address your excessive sentence claim?
My client is now out. He's served the carceratory portion of his sentence. He still has a period of supervised release left to go. We would ask your honors to release that time, to reduce that time. Studies show that any period of supervised release over a couple years is not effective or useful. My client is
wouldn't an argument like that mean that every case that came in front of us that had PRS, we'd have to reduce to 2 years or under?
Maybe, Your Honor, but here there's other factors. I think my client is a law-abiding family man. This is an aberration for him. I don't believe this extensive period of supervised release was necessary.
Okay.
Thank you.
Thank you.
May it please the court, Cynthia Carlson for the Office of Darcel D. Clark. Justice Neary properly presided over jury selection in this joint trial that involved 4 defendants. None of the defense attorneys properly preserved the arguments defendant now...
I want you to, just because our time on oral argument is limited, I want you to go beyond the issue of preservation, and assuming we can reach the merits, why on the merits is the defendant incorrect about what occurred during voir dire?
Sure. What the court wasn't precluding all questions about self-defense. In fact, many of the prospective jurors used the words self-defense. There were talks about fights. What the court did was narrow the scope of the voir dire so that the prospective jurors were not invited to give their opinion on the law. They weren't lectured on the law, but the theme, the idea of self-defense was certainly discussed. And as a result, the court properly permitted defense counsel to participate in a meaningful manner during voir dire, and defendant had a fair opportunity to question the jurors as is required by CPL.
What about the court's limitation on allowing any discussion of the concept of accessorial liability with the jurors?
So that was brought up initially at the start, right before the panelists were brought into the court, when co-defendant Fields' attorney asked the court, how can we talk about that? And the court offered that it would instruct the panelists that a verdict had to be reached on every individual defendant based on the evidence for that individual defendant, in sum and substance. And defendant's attorney said, yes, we agree with how the court is going to proceed. So
Haven't we held in the past that it would be appropriate for the court, for the judge who's presiding over the trial, to at least briefly discuss the concept of accessorial liability in connection with the prospective juror's ability to follow the court's instructions, and that the court did not do so or allow counsel to do so? I mean, that whole concept of acting in consort and accomplice liability, it seemed that he just did not really want to get into that at all, although that was an important part of this case with 4 different defendants.
While it was an important part of the case, the court didn't preclude all questioning whatsoever and didn't avoid the discussion of it when presented with the resolution of the issue, which is how do we discuss acting in concert. The court said, okay, well, I'm going to tell the jurors, you have to evaluate the evidence and give a verdict as to each defendant. And that was what defendant's attorney accepted as a reasonable response and a reasonable way to evaluate acting in concert. So yes, in cases this court has in the past said that courts can give instructions on accessorial liability, and in this case, Justice Neary followed a path that was approved by the defense attorney.
Did he do that each time there was a round of jury selection, or, I mean, did he repeat that each time, or did he not do that?
Initially, in the very first panel, he was more limited and narrowed in scope, and as jury selection continued, he allowed for more conversations about, in particular with co-defendant Fields' attorney, to speak on issues involving if the evidence against Fields, if you're looking at the evidence against Fields, you only look at his evidence. And the court didn't object to that question and didn't shut down that question. It was only then when defense counsel started to make a more misleading definition of acting in concert that the court then stepped in and said no. But even if Justice Neary was a little too cautious in his conduct, defendant still hasn't established prejudice. The defendant was convicted of the top counts in this case. He has no convictions related to Detective Seeley, and so it strains credulity that somehow he was prejudiced, because the verdict shows the jury was willing and able to follow the directions of the court. I would also note that
What is your response to your adversary's argument that when we look at prejudice, we have to look at the time that the voir dire takes place, and there's the selection of different prospective jurors rather than the trial itself?
Well, that it doesn't make sense then, right? Because the entire
I don't know.
My apologies, Your Honor. It doesn't make sense that prejudice is limited to the time of voir dire, because it's about the impact that voir dire, or the impact of jury selection has on the defendant's case. And in this,
Doesn't a lost opportunity to explore and voir dire necessarily limit the defendant's ability to put on the jury or exclude from the jury somebody that they might have otherwise done so?
well, except in this case, Your Honor, they still had peremptory challenges left. So if there was a question about an individual and that individual's bias or their inability to follow the instructions of the court, then the defense attorneys had the ability to strike them, but they didn't do so.
Then they're using peremptory challenges where they should have been able to reserve those and jurors that should have been excluded for cause.
But they didn't even use all the ones that they had. So there was no reason to hold on to the peremptory challenges if they were concerned about the ability of these jurors. I would also note that the two co-defendants that defendant had have already perfected their appeal, and none of them have raised this issue. What this suggests is that no one in that courtroom on that day, and based on this record, really believes that the defendant was deprived of fair trial based on jury
Just like
selection.
Judge Neary said, each defendant has to be convicted on their own facts. I don't think the fact that the co-defendants may have strategically decided to raise different issues on appeal reflects on the merits of this defendant's arguments.
But to the extent that that defense counsel is now citing for preservation Gonzalez's attorney, and Gonzalez's attorney may have preserved two areas of law, not all four, it certainly is suggestive that Gonzalez didn't raise this on direct appeal, and it's according to defense counsel, reversible error. So it's certainly not determinative, but it's suggestive about the meritorious nature or the merits of the claim.
Yeah.
If there are no further questions, the people will rest on our brief.
Good, thank you. Bottle?
Four things, Your Honor. The records could not be clearer that inquiry was blocked. Transcript page 705, nobody talks about the justification defense. I don't have the citation here, but with regards to acting in concert, it's in our briefs. Co-counsel says, you mean we can't ask anything about acting in concert? The court says, I just said that. These inquiries are fully blocked. Number two, separate verdicts is an entirely distinct legal concept from acting in concert. They're different. Inquiry into one and instructions on the other are apples and oranges. And while Mr. Fonseca's counsel did agree to the court instructing on separate verdicts, great, he never agreed to be precluded from asking questions about acting in concert. In fact, he tried to go there repeatedly and was rebuffed. Three, prejudice. There's no exhaustion requirement. I'd ask Your Honors to look at the Stewart case. It's exactly the opposite. The problem in Stewart was because of the limitations on voir dire, jurors were sat where counsel did not have adequate opportunity to explore their troubling answers. It's very clear in Stewart, and I believe in Miller, that not all challenges were exhausted. That's besides the point. It is very, very strange to hold the weakness of the people's case against my client. That they couldn't prove 6 of the 8 charges against my client does not mean he was not prejudiced when the other 2 counts came back as guilty, particularly when, if the jurors really fairly and impartially applied the core legal concepts of justification and acting in concert, that would knock out all the counts against him. I think it's entirely irrelevant to look at what co-defendants may or may not have appealed. It's just beyond the pale. You skipped over preservation. I'm happy to ask questions about that, answer questions about
Don't ask us questions, please.
I'm sorry, Your Honor.
I don't think we have any questions about.
Well, then,
do
to conclude,
Yeah.
voir dire is intended to identify jurors who can dispassionately judge the case at hand. It's not, intended to identify lemmings. This is the exclusive mechanism to vindicate the defendant's right to a fair and impartial jury. This court and the Court of Appeals have held that that right requires the defense to have a real and meaningful opportunity to explore issues that go to the heart of the defense with the prospective jurors. That didn't happen here. A new trial is required. Thank you very much.
Thank you. Thank you both. The next case is Curry versus Martin.
Good afternoon, Your Honors. Judy Shalmetzi from Wilson Elser for the appellants. I respectfully request that the order on appeal be reversed because the defendants established their prima facie burden for an entitlement to summary judgment on both prongs, both with respect to the alleged wrongdoing and with respect to causation, and the plaintiff has failed to raise a triable question of fact.
Well, with regard to causation, isn't there a clear dispute between the experts of plaintiff and defendant that creates a question of fact that would preclude summary judgment?
No, Your Honor. The reason there isn't is because the plaintiff's expert affidavit, to the extent that certainly there is one, but it lacks probative value because the plaintiff's expert did not see the wound or the scissor, is opining about the nature of the wound based on the plaintiff's description of it. If it were a trip and fall
Why
case,
isn't that okay, though?
why?
I mean, that happens.
Contradicts the medical records because the
That, I was going to say that happens all the time, where you get in an expert who looks at the medical records. The medical records have a report, whether, I know you don't agree with the report, but it does have a report by the plaintiff of how the accident occurred, and based on that information, the expert is opining. Why isn't that a legitimate basis for an expert to opine?
Two things there, Your Honor. With respect to how the accident occurred, how the cut occurred, the plaintiff has no personal knowledge.
We know that. So the question is whether there is sufficient, which really goes to the first issue, sufficient circumstantial evidence in this record that would create an issue of fact.
Correct.
And after all, that's all we're doing.
It is, Your Honor, and I mean, I can only lay out the factors, and I am of the view that simply saying that an instrumentality that may or may not have caused the cut exists in the house, and that this person knows how to use scissors, is insufficient to say that this person used those scissors to cut the patient's foot.
What about the additional fact that he noticed the odd straight cut on the leg, which would not otherwise be there? Isn't that further circumstantial evidence supporting that soon after that her leg started hurting?
It's not that soon after. It's 4 days after.
Okay, well, what about the cut on the foot? I mean, isn't that further evidence to support the son's claim?
Well, no, and the reason for that is because even though the expert says, and again, it sort of loops around, right? We're going back to the expert. The expert opines the way this cut was, even though I didn't see the cut, even though the contemporaneous medical records do not describe it as a cut, right? And that, by the way, is the only person who, the only medical record that exists.
The expert does testify that he believes, in his medical opinion, that it was caused by fecal bacteria, which would be consistent with the plaintiff's description of what occurred in the circumstantial evidence surrounding it.
But for the fact that that opinion contradicts the contemporaneous medical records, which clearly state that the cut, there's three wounds, right? There's the one that is alleged to have been caused by the scissors, and then there's the two that were infected that appeared later. And the first one that is alleged to have been caused by the scissor, the contemporaneous medical records say that it was not infected. So what happens was they wrap her, and then weeks later, she develops the same kind of ulcers that she had weeks before, and those are infected. But there is no way to connect with admissible evidence the first cut that healed and that both of the physicians who were there and saw that cut specifically observed was not infected. So the plaintiff's expert, on the one hand, can say anything, but on the other hand, in order for that to be admissible, in order for it to have probative value, it
Well,
must not contradict.
your expert doesn't explain how the bacteria, the fecal matter, that wound up in terms of the infection, wound up in her body on the bottom of her legs while she was in the care of the person who worked for your client, who actually did admit that she used scissors to cut diapers off of her.
2 points about that, Your Honor. The bacteria were not on the bottom of the foot. The bacteria were on the heel ulcer and were on the top, and were weeks after the original.
But you're missing the point. Usually fecal matter doesn't wind up in those places,
And I do understand
right?
that, but the claim again, I'm sorry.
Your expert doesn't explain that, nor does he explain, the growth of that bacteria and how long it takes before it manifests into infection and sepsis.
And that is a function of the bills of particulars. That is a function of the fact that the plaintiff's claim is very narrow. The plaintiff's claim is let me put it this way. The plaintiff's claim is not you failed to prevent infection by rendering improper foot care. And the reason that's not the plaintiff's claim is because the plaintiff specifically instructed the aide to not render foot care. So the plaintiff can't claim that. So the plaintiff is left on this weird claim of you cut her with the scissors. And that is the only claim that my expert is required to address. That is what we have to make a showing on, not on the entire.
Your expert didn't have personal knowledge about what the scissors were used for either, right? Yeah.
My expert opined based on the medical records and consistent with the contemporaneous medical records.
Okay, thank you. Let's hear from your adversary.
May it please the court, John Lyford of Denley and Carton, for the plaintiff respondent here. We are here to determine solely whether the court below was correct in finding a single issue of fact that precluded a finding as a matter of law. Only one single issue of fact was necessary. Just listening to the court now, I think that that's clearly met. I am prepared, though, should the court like, to go through the litany of issues in depth, one by one. Only one is necessary. Should the court like, I'm happy to do that. I'm happy to take your questions.
Well, we're not restricting what you're going to argue about. Your adversary raised 2 points. If you want to address them, I think that would be advisable.
Happy to address the points. First of all, there's an issue as to whether the employee used the scissors on soiled diapers. She says no. In her testimony, she told her employer, the defendant, that she did. She said, as is documented in the report, that she uses the scissors on soiled diapers, quote, when she has a bowel movement. There's an issue of fact as to whether those scissors were used in that fashion.
Well, and what links the scissors then to the heel? So we've got scissors to diapers. What links scissors to heel?
Great question. The fecal contamination and the straight cut and the pain and the lack of any other person who could have done this. The defendant concedes in their papers. It wasn't the son, couldn't have been the decedent. The only other person was their employee, Ms. Martin, who did use scissors on this person when diapers are soiled, breakaway diapers, mind you. And the son is contemporaneously very concerned about this. He sees a straight cut. He takes the scissors to the doctor. They get in 3 days, which is miraculous with internal medicine. In 3 days, shows the scissors. The doctor gives a tetanus shot. Only later did we learn about this fecal contamination. The concern, the contemporaneous concern just about the use of the scissors is corroborated by the conduct of the son. And then later, when we learn, wait a minute, fecal contamination in this wound, and I don't know why they keep coming up with multiple wounds. There's a heel wound. There's a wound that was trimmed on the heel, at the heel. The testimony is as clear as can be with not ideal questioning, that we're talking about a wound here. Well, that's what the medical records assert. There's fecal contamination in this wound. Their expert leapfrogs and says, oh no, there was no infection. Doesn't talk about a latent or opportunistic or inchoate infection that the plaintiff's expert talks about. Says there was no infection as of June 28, but then miraculously concedes that on July 3rd in the hospital, there was cellulitis and infection that the pathology showed was fecal contamination that our expert says is found from the perineal region and not on common surfaces. So all these things put together clearly are circumstantial evidence. There are multiple issues. They need to eliminate every single one, and I don't see how they've done that.
Any questions, colleagues?
I would ask you to affirm the decision below. Thank you.
Okay, rebuttal, please.
I'd ask the court to look at 147 of the record, which is the note, the contemporaneous medical record of the first physician on 6/13 who is there and looking at this wound. And he writes in his history what the plaintiff reports, that he says that she was cut with the scissors. But when it comes to the physician's impression, blister on foot, there is no social services concern that somebody's cutting this immobile patient. There is he does nothing with the scissors. He gives the tetanus shot because he was asked to. But his own impression, the physician's own.
Doesn't, I think it was the plaintiff's expert, I could be wrong, who said that it was consistent, that the straight line cut that that was observed, what could have been consistent with this type of a cut. And it seems like some of the places in your expert's affidavit are a little bit more likely than not. It's not logical. I mean, maybe it's more likely than not, but that doesn't mean it's absolutely impossible. I mean, it just seems it would be very difficult for the court to make this determination based on these expert reports we have before us.
Your Honor, I understand. I hear it. I hear the tone. I would just point out that the plaintiff's burden is to show that after us having carried our prima facie burden, I didn't do it, and there's an expert that says, based on contemporaneous medical records properly interpreted, that this is not that same infection because the hospital records show the location of 2 other wounds, including at the top of the foot. So that's the prima facie burden. After having done that, the plaintiff's burden is to show with a triable question of fact, which is to say one that is more likely than not. If this evidence went before a jury and the jury heard that there are scissors there and that she knows how to use them and that she has used them, it simply is not enough to say it was more probable than not that this specific act on her second day on the job, she took out those scissors and cut the patient with them. There's not enough evidence to say that that is more likely than not to have occurred. Thank you, Your Honors.
Thank you. Thank you both. The next case for argument is Jackson versus Main Street American. Just before you begin argument, just a quick question of curiosity. This case came up to us with this sealed marking, is that correct? Is this supposed to be sealed?
Jackson?
Yes.
I can't imagine why.
I couldn't either.
It's a...
we know what it is. We know what the case is about. But I just was wondering if there was something we were overlooking.
I'm unaware of that.
May have been, yeah.
Me? Okay, all right, thank you. That didn't take away from your argument time. I just want you to know that. It was for my own personal questioning. But now, your argument's on. Go.
Thank you. Good afternoon. Kim Townsend from Gallo Vitucci Clark for the appellant Main Street America. We are asking this court to reverse the motion court's decision that vacated the November 2020 arbitration award of Judge Kuttner. We're asking the court to do this for 2 reasons. The first, and the primary reason, is the motion court, and indeed this court, does not have the complete record of the proceedings of the arbitrator. Those were live proceedings. Judge Kuttner,
And they were not recorded, correct?
I beg your pardon?
And they were not actually recorded in any way.
Nobody brought a court reporter.
So, I mean, I read that, so under those circumstances, what is the court to do? Does that mean, well, we can't touch it, it's got to be perfect, we can't do anything about it? Or does it mean we have to send it back to try, well, I guess we can't reconstruct it, there was no record, there was no record.
Well, I think at this point is where the extraordinary burden of proof that is required for the plaintiff in this case to vacate the award of Judge Kuttner.
Which there would be any, I mean, that kind of burden in this type of case.
With any arbitration, but I think, and I brought a short selection of passages from this court, recent passages with citations, if you like, to if I can just use 60 seconds of my
Don't we have
time.
enough information before us to get to the merits of the case and decide whether or not the arbitrator did or did not exceed the power? We know what the arbitrator decided and what evidence was generally submitted. Why can't we make a determination one way or the other? And why aren't you focusing on the argument I thought you'd focus on, which is that the arbitrator has a lot of authority in these cases to just do what they wish to do, and that's not a basis for overturning.
Well, the arbitration proceeding is not a court of law proceeding. The arbitration is not bound by the rules of evidence, for example. These litigation reports were admitted without objection because that's the way it works. No hearsay rules are observed, no foundation requirements are demanded.
But I think more to the point is that when you're reviewing an arbitration award, we have such a forgiving standard of review that it's not the same thing as, say, when we review a trial court's decision on such matters. Isn't that true? So in
I'm
other
not sure
words,
what you mean by forgiving.
All right,
I think that punishing is a better word.
If the arbitrator makes a mistake, that doesn't mean that the arbitration is out with the bathwater.
That's exactly right.
Right.
That's part of the enormous.
They could make a mistake of law.
I
It
have-
doesn't matter unless it's manifest disregard of the law.
Why isn't that the argument you're making to us? That's what I'm mystified.
I'm sorry, I'm not hearing
Why
you.
isn't that the argument you are making to us? Why are we making it to you?
Well, I've been
Why
trying-
isn't that your argument that
It is my
that there's
argument. I was
more
about to.
deference
I
to
was-
their determination?
Well, it's not just deference to it, there's, I believe, by this court's own rules, the arbitrator's decision has to have been irrational as defined by this court,
Was
which
it
isn't the way we
irrational?
do it in ordinary.
Was it irrational?
Well, I'd like to read some of what.
No, you don't have to read our decisions to us. It's sort of clear we understand the standard of review when it comes to an arbitrator.
Okay.
So you could answer the question directly.
So what, I'm sorry then, what is the question?
You're saying, I assume you're arguing the decision was not irrational. Why was
Yes.
it not irrational?
It was not
You're
irrational.
arguing it was irrational because the amounts were so out of whack with what's normally awarded in these type of cases. What's your response?
It's not that out of whack. This court, this is the first department. You pretty much get what you get in the first department. This court has sustained.
We've never said that. I can tell you. You know,
Maybe that's.
But let's say, even if the arbitrator made a mistake and didn't give an award that was as high as otherwise you might get in a trial, is that a reason to otherwise throw out an arbitrator's award?
Of course not.
Okay.
Of course not. And just by the way, in answer to the question, I have some cases here from this court that are low six-figure cases on roughly comparable injuries and roughly comparable sequelae. So
But why are we even, I mean, isn't your better position that we shouldn't even be looking at comparables? Because if the arbitrator did the best that they could and was honest and came up, even if they made a mistake of law, mistake of fact, not reviewable here. Isn't that the issue?
yes, and that is our position. I was trying to respond to your colleague on that point, if you get to that point. But clearly, the law of arbitration and what is required to vacate an arbitration award is hugely steep. They don't have it here. And if you had the
I'm
record,
going to ask you to wrap up your
if
argument.
you had the record, okay, if you had the benefit of what Judge Kuttner had, which was, this was done on Zoom. He actually saw the
We don't need it. Let's hear from your adversary.
Thank you, Judge.
Okay, thanks.
Good afternoon, Your Honors.
These are really the arguments that you have to address. I looked at the lower court decision, and it was certainly a passionate and well-reasoned decision, but it looked more like what we do when we are reviewing the sufficiency of an award made by a jury, or when a court reviews an award made by a jury. It didn't look like, what it didn't look like is what we do when we have arbitration. Why is this violative of, or provides a basis for not confirming under Article 75 of the CPLR?
The basis is that the decision is irrational. It's not based on any evidence, including any evidence that was submitted to the arbitrator.
Well, I mean, even though, as we know, we don't have the record of the hearings, we do have a 7-page arbitration award where the arbitrator laid out pretty carefully everything that he considered, everything that he heard, the different witnesses, all the exhibits. It went on for several pages. So, I mean, he considered all those things. Some people he found more believable than others, which always happens to a trial judge or an arbitrator. And this is what he determined. What's irrational about it?
So even within his own decision, it's inconsistent. He finds that the plaintiff did, in fact, sustain a permanent consequential limitation, permanent, to his left knee as a result of this accident. Yet, he accepts, purportedly, Dr. Bezos, the defendant's expert's opinion, that he is fully recovered.
So isn't that a mistake? That otherwise still you confirm the arbitration award? He made a mistake.
Well, I think the mistake was even going through that entire analysis because the plaintiff had a fracture. So, I mean, that could be, even going through that analysis might be a mistake of law. But when you have your own conclusions, you find plaintiff credible that he has continued pain and had continued pain. I mean, this man was in the hospital for 6 days, 3 months.
He stated, though, that he did credit Dr. Bazzo's testimony that there was a full recovery and no further treatment was required, and that was the basis. So he did clearly state that. So if he did an error of law in terms of what satisfies a no-fault, consequential injury, that would not be a basis for us to overturn.
Right, that's not what I'm particularly saying here. What I'm saying is that in finding he had a permanent consequential limitation, but at the same time accepting testimony that he's fully recovered with no limitations, according to Bazos, that is irrational.
Well, isn't that just an error in law? That's my question. Isn't that just an error in law as to what is the consequential limitation?
I think it would be an irrational, and it's irrational, and that's what the lower court found, that it's inconsistent within its own findings. And
the lower court do what we said we're not allowed to do, which is to sift through the evidence and come to your own conclusions as to how to decide the case?
Well, it is a compulsory arbitration, so there has to be some evidence. The judicial scrutiny is a little bit higher when it's involving a compulsory arbitration like this one. So, I mean, the Share v. State Farm Insurance, the award must be supported by evidence or have a basis in reason. And I think the reasoning set forth in that arbitrator's decision shows it's not reasonable. There is no reasoning in there. It contradicts itself. It finds a permanent consequential limitation, yet also accepts that he has fully recovered.
I mean, I'm wondering if part of his evaluation, we're not going to know this for sure, was a reaction perhaps to the very large numbers that your expert doctors put on potential future medical care. I mean, I don't know if he's been doing arbitration for a long time, you know, some of the doctors that you put forward used to testify before me when I had the motor vehicle part 25 years ago. So they've been doing this for a long time, and some of the, you know, the arbitrators could listen to different people and evaluate all of their experience and say maybe some of that didn't make sense. I mean, they don't have to put all of that in there, but some things may just be, you know, just maybe I might have not decided that, but that's not the standard.
Well, the other thing that I think is irrational in the decision is the only evidentiary basis for the number that he puts, the 250, appears to be that Coleman case, which is not even analogous to this case before. So, you know, that case involved a simple knee scope. One of the plaintiffs in that case was found, they submitted serious injury to the jury, and they found he did not have a permanent consequential limitation.
But isn't that, if you're right, and I'm not saying you are, a mistaken law, that's not a manifest disregard of law.
But I still think it's irrational, and the award, if that's the basis for the award, that is not, that doesn't support the award. It's an irrational basis it's not based in any evidence before the arbitrator.
Okay.
And so all those things combined, that's why the lower court, I submit, properly found that the award should be vacated as irrational.
Thank you. All right, rebuttal?
I'm sensing from your questions that you're pretty well squared away. I'd like to take questions from you, to use my time, if you have any.
I'm not sure what you mean by squared away.
Well,
I don't know. We're asking questions, and we'll decide the case. So,
well,
there is your offer that you think we understand the
well, that's
issues
not,
that are in
I'm sorry if
dispute.
that,
Okay. Any questions, colleagues? All right.
I'm trying to
We
be.
thank your generous offer. It's a
Well,
generous offer.
I'm trying to
I know what you're
acknowledge that you don't.
We know the we know the law in the case. Yeah, I think we do, you know, and we'll give it fair consideration. Thank you.
I would just say then, finally, that if you get into the facts of the case, it's clear that Judge Kuttner was being rational here. I mean, at the very same time that the plaintiff went to Dr. Guy, who I believe was alluded to by your colleague, and Dr. Guy projected $2.2 million of future medical care. At exactly that moment, the plaintiff was seeing his own personal doctor and being cleared for resumption of duty as a bus driver, which also involved, the duties of which involved him helping elderly people to get onto the bus and get off of the bus. So on one hand, in December of that year, he was going to his doctor to be cleared to drive a bus again, a public bus with a CDL driver's license. At the same time, he was going to Dr. Guy and reporting vertigo and headaches and backaches and needing $2.2 million of care. I mean, it goes on and on, the level of disingenuousness of the plaintiff. And I could just go on and on about the facts, but I don't think you need to, because if there are any other questions.
Thank you.
Thank you.
Right, the next case is Kamara versus Century Management. You may proceed.
Good afternoon, Your Honors, and may it please the Court. My name is Lauren Bryant, and I represent the appellants in this case. We respectfully ask that this Court reverse the lower court's denial of summary judgment to the 323 Park Condo and Century Management defendants. Moving as a preliminary matter, Your Honors, to the 323 Park Condo defendant.
Well, doesn't the plaintiff concede that he does not, or they do not really oppose that portion of the motion?
Yes, Your Honor, and that was going to be my first point, that the lower court denied summary judgment and that should be granted on default.
All right, so why don't you spend your time on Century?
Sure, Your Honor. So looking to Century Management, the only testimony that this court should be concerned with is the superintendent for Century Management, which is Yusuf Akiz. We see his testimony on pages 437 to 438, 440 to 441, and 439 and 440 as well. He unequivocally testifies that Century Managed did not have any duties or responsibilities with respect to the adjacent property at 325 Park Avenue South. Century Management only had
adjacent. It was part of the same building, wasn't it?
So if we look at
with a different address, but it had this. It was the same structure.
It was the same structure, Your Honor, and if we look at Mr. Herman's testimony, if we kind of parse it out here, we know that back in, I think, 2011, 2012, the defendant 323 POS Associates purchased the building as a whole, and at some point thereafter, but before the plaintiff's accident, the building is almost separated into two addresses, and we know from Mr. Akiz's testimony that the buildings are, it's one structure, but they're completely separate entities here. They don't have any shared common areas, they have no shared entrance, exit, anything like that. I think the only thing that they share is there's an exit door somewhere in the basement.
Does it matter, or is it important in terms of summary judgment here that there wasn't a full contract with Century Management put into the record?
It doesn't for the purposes of our motion, Your Honor, and the reason is this. Plaintiff's counsel is essentially asking us, the residential defendants here, the residential owner and the residential management company, to fill in a gap of discovery that they either failed to obtain from the other defendants during the discovery phase or perhaps doesn't exist.
How do we know what Century Management's role is without having the management agreement? How do we know that Century Management doesn't play some greater role in the building as to both the commercial and the residential premises?
2 points to your question, Your Honor.
Why don't you put forth that evidence to support your motion, which you have the burden on?
Absolutely, Your Honor, and Mr. Akiz's testimony is the evidence that establishes that. There is no evidence.
His testimony can't establish what the management contract says. The management contract is the only thing that can establish that.
We don't
So
actually.
It would be helpful if you would address that question.
Certainly, Your Honor. We don't actually know if there even was a management contract. There's no testimony from anybody.
Wasn't there a first page?
There's a lease, Your Honor, with respect to 323 POS Associates and Casa Mez. But with respect to there being a maintenance contract of Century Management with respect to the building, in this record, I don't believe that there is any evidence to that effect.
We know it's not in the record, but all right.
So, Your Honor, so to that point, that there, at some juncture, the note of issue and certificate of readiness was filed. So I am appellate counsel here, and I'm not entirely sure what happened at the trial, at the discovery level. However, we know that at some point the parties stipulated that discovery had been completed in this case. So either the plaintiff failed to ask for any such contract or no such contract exists.
But if the burden's on Century Management, wouldn't Century Management have to say, there is no management contract, we've never entered into any management contract, such a contract does not exist, which would impose any obligations on us?
Not necessarily, Your Honor, because
Then how can you meet your burden under Espinal without setting forth that prima facie that we did not displace, there's no agreement by which we could have displaced?
Because your question, Your Honor, respectfully assumes that there is a management contract. And in fact, both Mr. Akiz and Mr. Herman testified, we've never seen a contract, we don't know. Mr. Akiz is the superintendent, Mr. Herman is the CFO of the...
Why shouldn't Century come forward with a statement saying there is no management agreement, as opposed to the court trying to guess whether or not there's a management agreement? Century would be the one who would have knowledge whether or not there's a management agreement.
Certainly, Your Honor, and again, I don't know what happened at the discovery phase, but I do know that Mr. Akiz, who testified on behalf of Century Management, testifies, I've never seen a contract. Mr. Herman's never seen a contract. By all accounts, perhaps there is no contract, but I think the important thing to note here is that Mr. Akiz's testimony unequivocally establishes that he's the superintendent, he's in charge of Century Management, and they never had any duties, responsibilities, anything whatsoever with that adjacent address. It was only with respect to the common areas.
Well, he doesn't indicate that his role, what role, if any, he had in signing contracts on behalf of Century if he's the super.
No, Your Honor, but when asked what documents he reviewed or where he got his information
A
from.
super may not have known of the existence of, may not have signed them, may have known of the existence.
And this particular super didn't even start working there until after the plaintiff's accident.
And in fact, Your Honors, we addressed that in our reply brief. Mr. Akis started within a month of plaintiff's accident, and he was trained by the previous super. Mr. Herman, however, is the individual who is supposed to have knowledge of all of these things on behalf of the parent company of 323 PAS Associates and its subsidiaries, which own the commercial premises. He's never seen a contract either. We don't know that there's any contract in existence, and I think to speculate.
Well, there has to be a contract, right? Whether it's oral or written, because this management services, Century Management Services, is not performing these services gratuitously, right? So there's got to be some arrangement, be it written or oral.
Absolutely, Your Honor.
Someone has to know the contours, and if they don't know the contours, assuming it's oral, then we would need evidence such as course of conduct to ascertain what the scope of the arrangement is.
Exactly, Your Honor, and I think Mr. Akis' testimony establishes exactly that, and to your point, perhaps it was an oral contract. Mr. Akis is testifying exactly what their duties and roles were that he was trained to do from the super that was there at the time of plaintiff's accident, which is within the same month. That's when he took over. So I think Mr. Akis, to your point, can testify and has testified with respect to any course of conduct that Century Management might have had at the premises. Thank you.
Okay, let's hear from your adversary.
Good afternoon, Your Honors. May it please the Court. Ian Ash for the plaintiff in this action. We know there is a contract regarding Century Management because the absolutely most knowledgeable witness, Mr. Herman, who's the CFO of the parent company that owns the whole building that's associated with all these entities, said that there was a contract. He said, I asked him, was there a contract?
And nobody ever asked him to produce it?
We asked them to produce, I'll point this out because this keeps happening. They never raised an argument that we never asked them for the contract. They just basically sidestepped the whole issue. When I put my opposition in, and the only thing I opposed was this aspect of Century's motion, when they replied, they don't submit the contract, they don't get any testimony from somebody who's in management at Century, as opposed to the building super who started a month later, to say there's no contract or the contract specifies this. They don't get testimony from the property manager. They don't get testimony from the prior super who was actually working there. They basically just ignore the issue. And the thing they don't do, and this is the most important point, they don't deny that a contract exists. I asked Mr. Herman, who's basically associated with all these companies, was there a contract with the management company that you're familiar with? Yes. He then subsequently says, when I tried to specify what were Century's responsibilities regarding the space of the Cava restaurant, it was his understanding that Century was responsible for the building at large, the entire building. I subsequently asked him, well, if Cava is having a maintenance issue such as leaking, I use that example, would they contact you? No, the first person they would contact would be Century Management. Their own witness from Cava, who was not really there when the construction took place, she said there were circumstances when they would contact Century. And I think a key point here is this is not as if this is one building, but also every one of these entities is interrelated. The 323 PAS LLCs are members of the condominium. So, during the pendency of this appeal, I emailed everyone and said, can you please send me the contract? I mean, I don't need to oppose this. If you could just show me the contract. They're militant about not giving me this contract. It would be like a landlord saying, we're not responsible under the lease, but we're not in any way, shape, or form giving you the lease. Or a labor law defendant saying, our contract does not make us responsible for this construction work, but we're in no way are we ever giving you the contract. And, I appreciate what they have to work with, their appellate counsel, but their superintendent, basically starts there a month later. He has no management role at Century. He never said anything about a contract, even if he, in his time.
I mean, it seems like Mr. Herman's testimony creates the issue of fact.
Yes, Your Honor.
And I don't know how you get past that. Or, you don't, right now, that's not your problem. It's your adversary's problem.
Yes. Thank you very much, Your Honor.
Okay, thank you. Any rebuttal?
I'm just wondering, how do you get past Mr. Herman's testimony, which I recall looking at, that said, yes, they would come to us first, or we would go to Century if we had some questions, and nobody said, nope, there's no contract, which, as my colleague Judge Hickett says, doesn't make any sense, because these management companies, and this is a big management company, just doesn't work for a company because they have nothing better to do, and there's got to be some kind of an agreement. So it just doesn't make a lot of sense.
Yes, Your Honor, and a few points to that issue. First, I think we have to look at Mr. Herman's testimony as a whole, especially on pages 375 to 376, which I believe opposing counsel is referring to. Have you ever seen the contract with a management company you're familiar with? No. All of his questions, I don't recall, most likely, I don't know, I don't recall exactly, I don't believe exactly. Mr. Herman is the CFO of Tesla, which is a parent company of Poss Associates, which is a parent company of these other subsidiaries that own the commercial premises. He is not in a position, and his testimony is unequivocally clear, that he has no idea about the inner workings of any such contract and is only speculating that perhaps the contract exists with respect to the commercial premises.
Wait a minute,
Aren't we all
I think you're misstating the record on 376. Mr. Herman is asked, was there a contract with the management company? And he says, yes. Does the contract specify what portions of the building? Yes. That seems pretty unequivocal to me.
Yes, Your Honor, but if we look backwards at his testimony and then forward, so if we look at the preceding pages, I believe it's 374 to 375, or maybe it's just on 375, and then I believe again on pages 385 to 386, he really is just speculating here. He'll say yes, and then when he's asked to clarify, well, I don't actually know. Well, I've actually never seen a contract. Well, I'm not sure what.
But aren't we all speculating?
Yes,
I mean,
and
that's
No one in this room, I think, has seen that contract.
absolutely, Your Honor, and I think that goes to the fact that perhaps it was just a course of conduct that was established with.
But your client, I appreciate your appellate counsel, but your client knows the answer to this. Somebody within the Century organization knows. And don't you, on your motion, have an affirmative obligation to describe the appropriate contractual relationship? And I don't know that you can do that with the super. I mean, the super may have the day-to-day maintenance responsibilities, but I don't know that that person has the corporate responsibilities to negotiate and sign contracts.
I think two things to that, Your Honor. If we look at Mr. Akiz's testimony, he is the person in charge of all the other employees working for Century, and he lays out the duties and obligations day to day. If they are never going over into and he unequivocally testifies to this, they are never going over into that commercial premises whatsoever. And I think
Mr. Herman testified opposite. The problem is your burden on summary judgment. I just,
to that, Your
I'm
Honor,
baffled.
I would just say that Mr. Herman speculating is not enough to rebut our prima facie burden.
He's your witness.
Mr. Herman's not our witness. I know it's confusing, but I believe he's the witness on behalf of the other
You're right,
group
the
of
owner.
defendants.
But that is part of the confusion in this record.
Yes, Your
Who owns this? Who's responsible for this? Whether Century is employed just by the residential? Does Century have any obligations with respect to the commercial premises? Even though the commercial premises are described as being separate premises, they are actually physically in the same building. They may have a different address. I just don't understand, without the resolution of these as a matter of law, how you get summary judgment. That's my own personal view.
And to that, Your Honors, I would simply ask that you view Mr. Akiz's testimony in conjunction with Ms. Harvey's testimony, who was the CABA manager, who stated, and everybody has unequivocally stated, that regardless of anything else, the stairway was an exclusive possession of CABA. Nobody maintained that stairway except for CABA and its people. So in this separate commercial premises, taking Mr. Akiz's testimony, taking Ms. Harvey's testimony, and taking the lack of knowledge by Mr. Herman, I believe we have met our burden on summary judgment. Thank you.
Thank you. Thank you both. Steelman versus Transervice. can proceed.
Thank you. Good afternoon, Your Honors. My name is Eitan Ogan. I represent the plaintiffs' appellants in this matter. In this case, on this motion, the defendants failed to meet their burden of establishing entitlement to summary judgment under the Graves Amendment. Basically, there's two defendants that moved for summary judgment. One of them is the owner of the truck, one's the owner of the trailer. Transservice, the owner of the truck, who had previously been, plaintiff had previously obtained summary judgment against all of these defendants on the issue of liability, both
we affirm that.
on liability
Right.
and under negligent entrustment of all the entities, and no issue of Graves was raised at the time. On this motion here, many years later, they come in and they say, well, Transservice was really, should be shielded by Graves. However, their driver, Stroud, in his own testimony, said on a couple of occasions that he's employed by Transservice. Later, he says he's also employed by JED, but he never takes away the fact that he said he was employed by Transservice, and nobody else does either.
Evidence in the record from any party as to employment records with respect to him, paychecks, anything which would answer this question? No one submitted any evidence.
Nothing. And
So
it's
just a
again,
statement
it's
of
their
the
burden.
various
And
individuals.
correct. There's absolutely no evidence as to who he's actually employed by. And he never corrected the transcript. They never submitted on their motion anything to, correct the record in any way.
It's not correct. They did offer a different point of view. They had somebody from the Transservice Lease Corp. Who submitted an affidavit and said, no, he doesn't work here. So now we have.
They didn't say that. They said he's employed by JED. They didn't say he's employed, and they didn't. He could be.
The natural implication of that is he's not employed by Transservice, right?
It's an implication, but he could be employed by both, right? That doesn't.
I have no idea
exactly,
because there's not a shred of a document for a pay stub or anything, but that would normally really be appropriate.
And that is my point as them not meeting their burden. It's not up to me to prove who he's employed by. It's up to them to prove it.
So what about the separate issue of whether or not this particular tractor is or is not included under the equipment lease, which has been submitted?
Well, yeah, I was going to go to that next, is these agreements don't specifically highlight this specific tractor.
It's not a question.
Not the agreements, not the invoices.
They never even mentioned this trailer, right?
Not mentioned at all, correct. And then with regards to Wakefern, I mean,
Well, the documents regarding Wakeford seem like they are paying other people to haul their own goods. So I'm not sure how that fits, or I think that's the problem with why that would come anywhere near the Graves Amendment.
Yeah, exactly right, Your Honor. They have to be a bona fide commercial lessor, which clearly they haven't even come close to establishing that. So, aside from the fact that, we have that other decision that I don't think they've, actually properly dealt with that issue, even if you put that aside, they have not met their burden to establish that they're bona fide commercial lessors as to Wakefern and as to Transservice, that Mr. Stroud is not employed by them.
Yeah, but, the threshold issue here, before we even get to summary judgment, is the issue of allowing them to amend their pleadings. Yeah, and that's a different standard, correct?
That is a different standard. I think the main issue with allowing them to amend the pleadings is they want to, initially they were all represented by the same counsel for years, for 7 or 8 years. They're represented by the same counsel. Then they decide that they need to separate it out, which for reasons, I don't know if you want me to get into it, but they separate it out, and now all of a sudden they're doing cross claims against each other, and now they're saying, oh, we are lessors, even though for 7, 8 years, through summary judgment, we denied that we were lessors. Now Wakefern wants to change it and say They are a lessor, and they want to interpose cross-claims against the other defendants.
How was your preparation of your defense to the Graves Amendment hindered by their delay, their unreasonable, unexplained delay in interposing this Graves Amendment now?
So because we had prevailed on summary judgment on liability, and that was never re-argued or appealed, I was under the impression that we had summary judgment on liability, right? We have 100% liability against each defendant. We never sought to depose the owners, which we would have had liability been an issue, had Graves been an issue, and we would have, requested other discovery that we never, relating to Graves Amendment, that we never got to, such as the pay stubs and things like that.
I'm sorry. Is that discovery now unavailable? Is it unobtainable at this point?
I mean, the case is almost 10 years old. We're trying to, put it, my client just had another surgery, so, we're trying to put it back on the calendar now,
No, I understand.
to reopen everything now, yeah.
My question time, but the nature of the information, has it disappeared because time has passed? I don't know.
I wouldn't know that, I'm sure, after so many years, information has disappeared and memories have faded. But, the whole point is we're litigating this case under one presumption for all these years, a case where the accident happened in 2013, and now to go back and reopen everything because, they want to, change their whole litigation strategy, I don't think is fair to plaintiff.
Thank you.
Good afternoon. May it please the court. Adam Ostacher on behalf of both respondents. And I'm just going to...
Do they stand in the same shoes with respect to the defense of the Graves Amendment?
Well, if I could just address the Graves Amendment and the comment Judge Higgett made. The Graves Amendment...
I'd like you to answer my question, but I'll give you some flexibility here.
I think they do, and I have a more expansive answer to that, and I'm going to address the issue you raised with the Wakefern lease agreement in answering that question. But with regards to the Graves Amendment, it was pled in the initial answer in this case. So back in 2014, it was pled.
Counsel, my question, assuming you allowed to amend the pleadings and we're getting to the merits, where is Schedule A? Why isn't Schedule A, which would show what tractors were actually leased under the agreement, annexed to your papers to establish that the tractor in question was a tractor that was covered under the lease?
Well, just to address the question raised by Judge Gressmer earlier, and your question as well, there was evidence admitted during the summary judgment phase establishing incontrovertibly that the subject tractor and the subject trailer were both leased pursuant to these respective agreements.
What's the evidence?
What would that be?
What's that?
What would that be? What is that incontrovertible evidence?
It's the affidavits of the Wakefern and the Trans-Service people.
Documentary evidence to support the affidavit. Where is the documentary evidence? Which should exist if it is true that this was leased under an agreement. Where is the documentary evidence to support that claim?
And as I argue in my brief, I don't think there need be documentary evidence to further corroborate or establish what has already been established and wasn't controverted in the two affidavits submitted by the respective people.
Counsel, that's your burden as opposed to theirs to controvert. The issue is whether or not this was covered, and that's your burden, and certainly the best evidence of that would be the document that lists the trailer and tractor as covered.
I don't think that would be the best evidence if no such document exists, and I can say that it does exist.
Well, there is a sort of an oblique reference to the Schedule A, which is not provided, which seems to list the vehicles that are covered under the master lease, so to speak. So what do you mean it doesn't exist? It looks like it exists or may exist.
I'm not saying that Schedule A doesn't exist. I'm just saying that there, as far as I know, there does not exist a master document listing every truck and every trailer.
You don't have to list every truck, and all you have to list is this particular truck.
I don't think you have-
Right?
I don't
Am I
think-
wrong about that?
I don't think there has to exist a specific document saying that every truck or every trailer that was covered by this lease agreement.
Not every, I don't care about everyone. The question is, you have to show that this one was leased, right?
Which we did by way of the affidavits of the two employees. from
Referring
Wakefern
to
and
a
Trenton.
document that was incomplete.
They referred to a number of documents, and I don't think it was
They
incomplete.
referred, you still never answered my specific question about Schedule A. They specifically refer to Schedule A, which is, I assume is a list of the tractors being leased under the agreement. And you mention Schedule A, and you don't attach Schedule A to your papers.
I cannot say that Schedule A listed all the trucks or trailers that were under this lease agreement.
Say that you don't know if that exists. Exhibit page 216 of the record. I'm sorry.
Thank you.
Page 216 of the record, explicit, which is the equipment lease agreement, says the equipment that is covered by the agreement is in Exhibit A, and Schedule A, and you don't have it. So I'm baffled by your saying that Schedule A might or might not exist. You specifically refer to it.
I'm not saying Schedule A might or might not exist. I can say that Schedule A definitively lists every tractor and every trailer that is responsive to these respective lease agreements.
Except that the lease agreement says that that's exactly what Schedule A does.
I rely on the evidence submitted in these two affidavits. I can't say what or what does not exist in Schedule A, but we do have evidence showing that both the tractor and the trailer were leased. And as far as, to go back to the initial issue as to Wakefern, this is a lease agreement under the Uniform Commercial Code.
Yeah, but the lease goes, it almost goes the other way. He's not, Wakeford is not getting money in exchange for its leasing the trailer part of this vehicle. In fact, it seems, as I read the documents, that although the parties using the vehicle made certain representations about damage and insurance and maintenance, that in fact, Wakeford was paying these people to haul their goods. How is that a lease, as we understand that, under the Graves Amendment?
Well, under the Uniform Commercial Code, that is just what a lease is. Under UCC 2-A-103 subsection P and subsection J, a lease is a transfer of the right to possession and or use of goods for a term in return for consideration. It's temporary.
Well, what's
it
the
can't be a sale.
consideration?
The consideration is the drivers operating the trailers, right? Wakefern they can't use a trailer that would be used to haul wood, right? They have to maintain the produce, so they have their own specialized trailers.
Right,
So
that they own.
And they own or they lease them.
To who?
And
Who do they lease them to?
They lease them to JED, who is a company that is.
I didn't see that, but okay. All right, let's hear a rebuttal from your.
Can I just address lastly the issue of the employment of Mr. Stroud? Can I just, one last point, which was raised?
You have 1 minute.
I appreciate it, even less.
Okay, I'll hold you to that.
And I do appreciate that. In plaintiff's amended complaint, they allege that Mr. Stroud is an employee of JED.
Right.
JED, in their answer, concedes this. Former Judge Richter, in GJF versus Sirius Insurance, in her concurrence, she noted, and all she did, I mean, she was quite capable of heavy lifting, but this was very easy. It's Hornbook law. She cites to Prince and Richardson, in that, in a pleading, if it is conceded that a fact exists, it is conclusively established. So I raised this case, I raised this issue in my brief.
So it doesn't really matter that you have an affidavit regarding this. You're relying on what you think is an admission in the pleading.
I have the admission that is conclusive evidence in the pleading. I also have, and in Mr. Stroud's testimony, he didn't know who he was employed by. And then we have the affidavit submitted establishing he's established by JED.
Okay, but it's true, we have no documents here, pay stubs, anything like that.
It was conclusively established by way of...
So again, you're relying on the pleading. I think I understand that. Okay. Thank you. Let's hear from your adversary.
Okay.
Could you deal with that last issue first, please? Did you, in fact, concede the issue of Mr. Stroud's employment by JED?
No, that's misrepresented. In our complaint, we alleged employment by all the entities, because in the beginning, you don't know who he's employed by. So we alleged employment by JED. We alleged employment by Trans-Service.
And you did so on information and belief?
As in, yes, the whole complaint is that way. JED admitted that they were employer, but that doesn't mean that nobody else is also the employer, and that doesn't, establish on summary judgment that he's not also employed by Trans-Service. If you read his transcript on page 322 of the record, question, were you employed by Trans-Service Lease Corp. From what period to what period? I was hired in 1999. Until when did you work for them? Until 2014. And then, I keep asking him that. Were you employed in 2013 by Trans-Service Lease Corp? Was I working for them at that time? Question, yes. Answer, yes. And did that also include the date of July 27, 2013? I believe so. And then later on, he says that he believes that they're both the same company. There's a whole series of questions. It's not just one question. It's a whole series over the course of 3 pages in the transcript where there's a big issue of fact. And they never corrected that. They never set the record straight. It's their burden on this motion to do so. Thank you.
Thank you. Thank you both. Okay, the next case on the calendar is Ahmed versus 2 West 46th.
May it please the court, my name is Noah Kinnickstein, and I represent Mohiuddin Ahmed, the appellant herein. This appeal is taken from a lower court decision which granted summary judgment. The appellant has appealed because the court failed to consider all of the relevant facts in granting summary judgment and stated in a very short decision that the only basis that he was, court was granting summary judgment was because of, felt that the remarks of his supervisor were stray remarks without considering any of the other facts, any of the other considerations such as violations of procedure that existed at the defendant, the respondent's location. They terminated him. They violated, the procedures that were in place even since prior to the union, prior to when the union left, that existed going forward as well, were all violated.
Well, what were the specific procedures that were violated?
The ones that were violated was the way you requested a vacation, the fact that it would be transmitted to the management, the fact that he was entitled to get his vacation pay at the first day of when his vacation began, the fact that he was entitled to his full vacation pay at the point that he was terminated, and on top of that, the violations of not contacting him, of submitting letters saying that he received, which he never received, about work that he didn't do. The letters themselves are clearly aimed at the day staff and not him. This is a man that worked for more than 25 years cleaning toilets for this building. from 12 midnight to 6 a.m. He would come in, there was never any problems with this man. The union then bows out at a certain point. He's left with no defense. The person who he was working with becomes his manager, and he tells him, I'm going to my daughter's wedding, as he's always done, 3 months ahead of time. He filed the vacation papers, just the way that you're supposed to do it. He reminded them of it. And the day that he's going to leave, they not only don't give him his vacation pay, they give him a termination letter, making all kinds of allegations which aren't true.
But
The judge ruled
they
that
didn't actually have to state any reason for terminating him, right? There was no union.
there's no reason.
So, but they didn't even have to state a reason, correct?
Well, no, there's no requirement to state a reason, but the allegation, he did say that, they did say that because of complaints from the tenants.
Right, I understand, but in a company without a union that's not part of the government or anything else, there's no requirement that they have any reason for firing him, right?
No, but they can't discriminate.
Right, but what evidence is there of discrimination other than these two stray remarks?
The fact that they violated their own internal procedures for the first time. That's a deviation of the way they admit that they're supposed to treat people, and when they don't treat him that way, that's an inference of discrimination.
What about there was evidence that they had told your client a few different times about some of the problems that tenants were complaining about the cleanliness of the bathrooms, which was his job. And so he knew that there were some complaints. This wasn't the first time he heard it, or is you disputing that testimony?
But he stated he never got those letters. And if you look at those letters, they don't specifically say it's for his shift, it's for the day shift. He was not on the day shift. The person that's on the day shift who admits that there were problems in the bathrooms was his boss, Rodionov. He's the one who has to go and clean it up. He came in at 6 a.m. and worked till, he came in at midnight and worked till 6 a.m. And that those complaints are all about what's happening in the day. And they blame it on him. And that also raises an inference of discrimination because they're lying. And they're not telling the truth, and he never received those letters.
Well, he did at least receive, there was a letter given to him indicating that he was suspended for a period of time for what at least his employer described as poor work, right? So he got at least that letter.
No, that isn't true. In fact, that was...
What's not true? That he wasn't suspended?
The fact that he was never told he was being suspended, and he never testified to that.
He was never suspended.
And that's correct. He was told to take 3 days off because they were trying a new management, they're trying a new company. That company then took over from him after he was fired. But he was never told that he was being suspended for any reason at all.
Is there any further relevance to the fact that another company took over those obligations as opposed to another individual appointed? So it wasn't like they terminated him and then took somebody else from the company, but they brought in an outside company to now be the cleaning company.
That's what happened.
So does that cut any weight towards your discrimination claims?
No, because you can prove in a discrimination case that if someone younger than you is hired, that can lead to an inference of discrimination. But that doesn't mean that they didn't, that's not the only way to prove it. And in this situation, even the fact that, also this concept of stray remarks is tricky, because the courts just say, oh, it's stray remarks, we're going to ignore it. But stray remarks have to be couched in the context of what's going on. And actually, I've cited cases in my brief, I'm not going to go through the case law here, that say that the whole concept of stray remarks is a flexible concept. It doesn't mean that you say stray remarks or you ignore. It just gives an indication of whether of the strength of the remarks themselves. But when matched with the type of the abusive way he was treated, like a piece of garbage, he was kicked out like that after 25 years when he's on the verge of going to see his oldest daughter's wedding, a man who came from Bangladesh, who came here and worked, and then they don't, and then all of a sudden they never get his, they say for the first time ever, they didn't receive the vacation voucher, which is the first time it had never happened before. This is all in my brief, by the way. It's all in my
Right,
brief.
and we've read the brief, so
Okay.
let's hear from your adversary.
Okay.
Yeah.
Good afternoon. May it please the court, Matthew Brown from Millman Labuda Law Group for respondent. We ask that you affirm the decision granting
Yeah.
summary judgment.
All right, so let me ask you a question. In the rubric of how to decide these cases on summary judgment, we really, in this case, we get to the point where you have proffered a reason or a non-pretextual reason for otherwise dismissing the plaintiff in this action, correct?
Yes.
Right, and then he raises all the things that your adversary just discussed. Why don't those things at least provide the basis for an issue of fact such that we don't have summary judgment and we should go and put this matter before a jury or a finder of fact?
Well, there's no issue of fact on a lot of the issues that he raises that fall in our favor. A lot of the points that my adversary makes in his brief are conjecture or speculation or based on irrelevant evidence. The fact of the matter is my client is a landlord. It received tenant complaints. The veracity of those complaints or whose fault those complaints are is irrelevant.
Well, sir, what about your friend's argument that those complaints were lodged against the day shift and not against his client?
Well, there is no day shift in the building. There's one person who was assigned specifically to cleaning in the building, and that was Mr. Ahmed. The coworker who he referred to was also a maintenance superintendent. He was, as Mr. Ahmed admitted at his deposition, the messenger. So the saying goes, don't kill the messenger, which goes to the stray remarks. But he would only clean up during the day if there was an emergency or there was a call made. It was not his specific job to do that. So once the tenant complaints were received, as a landlord, my client had an obligation to remedy those complaints in the normal course of its business, and it made a business decision to hire an outside cleaning company to do so. The burden then shifts back to Mr. Ahmed to prove that that was a pretext. In order to do so, he would have to prove that those tenant complaints were forged. During discovery, although those complaints were turned over, he never subpoenaed or sought any discovery from any of the tenants. So from our perspective, there's no issue of fact with respect to the legitimate business decision that was made by my client.
What about the quote-unquote stray remarks coupled with the deviation from the policy about giving the vacation pay ahead of a vacation, about not approving the vacation?
Well, let me address the quote-unquote violations of policy first. The policies that plaintiff refers to were not policies at all. The collective bargaining agreement had expired, and thereafter, the only testimony in the record was that the amount of vacation that employees were entitled to was the same as when the union was contracting with the building. There was no policies about just cause termination. There was no policies about when vacation would be paid. And it's just not true. And as far as...
After the expiration of the collective bargaining agreement, did the defendant have a procedure regarding the collection or the payment of vacation pay?
Well, that wasn't explored by plaintiff during discovery. The testimony on the record was that they were entitled to the same amount of vacation pay as before. But it's axiomatic that if someone's terminated, they're not automatically entitled to accrued but unused vacation pay. At the same time, the person who was in charge of collecting the vacation slips, the request slips, testified that it was common for him not to submit the slips to management as long as he had coverage in the building. They were not concerned about who was taking vacation when. So it was actually common practice for him not to submit the vacation request, and there's no evidence or testimony that the management team that made the decision to terminate Mr. Ahmed's employment had any knowledge that he was going to take vacation. While it may be, you know, a awful situation for him, bless you, the human rights law is not a code of civility. It only regulates whether there's discrimination, and we submit that there was none. Thank you very much for your time.
Thank you. All right, rebuttal, please.
It's not true. In fact, when I deposed Ms. Sofer, Chaya Sofer, who is the director of accounting, about whether the policies that were in place at the time the union was there, were they still in place? The answer was yes. It's on page 12, 13, 14, and I think up to 15. I go through that testimony. I asked her specifically about the vacation pay policy. It's the same, she said. I said, would he get his pay? Yes. Did he follow the right rules? Yes. He submitted the form. So it is their own witness said this. Okay, it was stated. In terms of Mr. Radionov and the bathrooms, I quote, he stated that the messes in the bathroom during the day could happen as many times as once a week. That's not occasional. And that's what these letters, if you read them, that were submitted by the head of the corporation that responded to, was part of their motion, said. He said, well, that these were all his fault, although if you read the letters, they're very specific about during the day, the bathrooms are disgusting. My client comes in at midnight, cleans the bathrooms. There's no complaint about the morning when the people come in, and he's blamed with it. And Radionov, the guy who lost his ticket, can't remember if he gave the vacation ticket in, swears during the deposition that the bathrooms would get messed up during the day before the cleaning staff started their shift, and he would clean them up. What else? What does this start to sound like? A setup. That's what it is. Because they were blaming this man for something he didn't do to get rid of him, and they didn't follow their own rules, and that is the beginning, the end of this, and the judge didn't consider any of this. And for that reason, summary judgment should not have been granted. It should be reversed, sent back to the court to consider the other facts in the case. As far as I'm concerned, there's an inference that we beat summary judgment altogether, and the case should be sent back for a trial.
Okay, thank you.
Congratulations, Your Honor.
Thank you. And I'm going to, right, you're the last case that I will hear in my judicial career. And I always give special thanks to the last case on the calendar, because I know you've waited a whole afternoon and heard our old calendar just like us, and I appreciate your patience and your good wishes.
Thank you.
All right.
Thank you. And the same way with your grandson, I call my daughter delicious. He's a year and a half.
And I'm sure she is.
Oh, sorry.